Afternoon. This is a hearing on the defendant's motion to amend bail in the matter of State versus Britany Barron, in which the parties appear by WebEx. Would counsel for the state please identify yourself?
Scott Chase for the state, Your Honor.
And would
Attorney
counsel
Agati
for
for the
the
state, Your Honor.
Okay. And which of you, Attorney Agati or Attorney Chase, will be speaking for the state today?
I will, Your Honor. Scott Chase.
Very good. And would counsel for the defendant please identify yourself?
Good morning, Your Honor. Richard Guerriero for Britany Barron.
Okay. And Ms. Barron, have you been able to hear myself and all of the attorneys just now? Ms. Barron, are you able to hear me?
Yes, Your Honor.
And were you able to hear the lawyers just now?
Yes, Your Honor.
Okay, if at any time you can't hear anyone, let me know and we'll do what we can to fix that, okay?
Yes, Your Honor. Thank you.
Okay, so Attorney Guerrero, I understand the parties are proceeding by way of office of proof. I have reviewed your motion and the state's objection. So Attorney Guerrero, you may make your motion.
Thank you, Your Honor. And I'm not going to reiterate what's in the motion. As you said, I know you've read it, and I know you're familiar with the case from the prior bail hearing and also from the dispositional conference. So I want to get right into what I think are the key issues in the case. And my first primary point for the court is that most of the state's arguments are out of context. And I want to put those points that they make in context. First of all, when the state describes its concern about any risk that Britany poses, they completely ignore the fact that she is a victim of domestic violence. And I want to summarize for the court the evidence from the state's discovery that demonstrates that she was, at the time of this incident and for a long time before, a victim of domestic violence. Among other things, the state interviewed some of her co-workers, and I will read to you some of their descriptions about Britany's relationship with Armando as they saw it. A first female co-worker describes Armando Barron as very controlling. She said that she knew about the, quote, abuse. She said that Armando would not let Britany drive herself to work. She said that he would drop her off and pick her up. And in her words, quote, she described him as very controlling and very possessive. A second female co-worker described Armando by saying he did not like her to have friends. She was not allowed to go out with friends that she knew from work. Basically, the only socializing she did was with friends from work because Armando did not allow it. Before this incident, Britany had reported to this second female co-worker that Armando had hit Britany when she said that she thought the marriage was over, and that she described it as hitting her or slapping her, and that's. I'm not going to give the names of these witnesses for their sake. I'm just going to describe that as the second female co-worker. A third co-worker repeated the observations that Armando would not let Britany leave him, that he would not let her hang out with friends, that he, quote unquote, smacked her in the face when she asked for a divorce. And then just to the extent there's any concern that this is talk with her women friends at work, there's a male co-worker who also described who said he had known Britany for a long time, for years, described Armando as possessive, that Armando hit her when she said she was leaving him, that he would drop her off and pick her up at work, clearly controlling her behavior, and would not allow her to go out with friends. I mean, these are co-workers independently reporting the same kind of abusive and controlling relationship. And interestingly, when these people from the company where Britany worked were asked about who they were afraid of, they said they were afraid of Armando, not Britany. And that's certainly relevant to the court's determination here of whether there's a risk to the community. And Britany herself, of course, described this situation and said she had been trying to get out of her relationship. So it's in that context where she has exchanges over text and talks with Mr. Amerault, and then is discovered by her husband. And I want to read to you some of her account because we didn't have the time of the last bail hearing, but we now have some of her account. I mean, the court knows that generally that Armando found text messages on Britany's phone, and then he beat her in the bathroom of their home in response to that. The way she described that was he grabbed me by the neck and threw me down. He showed me the phone. I'm quoting her. He put the gun in my mouth and I kept screaming, so he choked me so my girls wouldn't hear me, referring to her daughters. Later, she says, when he's reading through the messages, he was hitting me with every message he read. My nose was bleeding so much. My head hurt so bad. I have a cut here, referring to a spot on her head. She said when he was holding her by the throat and slamming her down and choking her, she said to herself, "I'm going to die." And when she just describes in a later part of the interview, they come back to him putting the gun in her mouth, and she quotes Armando as saying, "When the gun is in her mouth, I should kill you right now." That's how this situation began, and that's the state of mind that someone that was already a victim of domestic violence was exposed to when Armando then lured Mr. Amerault to the park. As you know, there's a state park area where Armando lured him there. He beat Mr. Amerault. Armando was armed with a gun. He continued to beat Britany on the way over to that park. And Britany was there. And I'll stop here and say that one of the state's arguments is that when Mr. Amerault got to the park, that Britany did not do anything to warn Mr. Amerault that he was about to be attacked. And I'd ask the court to consider her mind at that moment. A longstanding victim of domestic violence who had been beat before, whose friends and coworkers described the husband as abusive and controlling. There she is, beaten, and you've seen the pictures that I put in my motion, both eyes blacked, beaten in the head, with her nose bleeding so much, with her head pounding, and the state would expect her at that moment to be thinking rationally. And I would suggest that that's just not reasonable and fair to expect under these circumstances. The situation continues, as the court knows, and essentially Mr. Armando Barron continues to beat Jonathan Amerault, and he tries to force Britany to kill Jonathan Amerault. And at that point, despite her circumstances, despite all of the abuse, despite her injuries, she refuses to kill Jonathan Amerault. She refuses to kill him. She is forced into some conduct that it does not result in death, and I believe we now have the autopsy report. I don't believe would have resulted in death. But when it came to the point of the gun in her hand, shoot him, she refused to do that. And I have a different interpretation of those facts than the state. I think that the fact that even with her own life at risk, having been threatened with a gun in her mouth, that she refused to take Jonathan Amerault's life, that shows that she is not a dangerous person, that she, and to the contrary, that she's someone that she knew she might die herself, and she still refused to take that action. There was a point after that that the state draws the court's attention to where it was immediately before Mr. Amerault was shot, where Armando Barron is in the passenger seat of Mr. Amerault's car, and he's made Britany get in the front driver's seat because he's going to make her drive her car. And then Armando gets out briefly. And the state says that in their motion, well, she could have armed herself with the machete in the car and attacked Armando when he came back in. And the only reason they know about this, or any of this, frankly, is because Britany told them about it. I mean, they're using her statement, but this is what she told them. And she said, I was afraid to do that. And I want to quote to you from her statement on that as well. And she said, Jonathan was still alive at that point and said, pick up the machete and kill him. And she said, I'm not going to kill him with that blow, meaning she wasn't going to be able to do it. We're both going to die. And then she explains later that she was holding out some hope that they had a chance. She said, I'm not going to be able to deliver anything that's going to, and she obviously meant kill him. It's going to piss him off and we're both dead. I told him to be quiet. Let's just stop. He hasn't killed him yet. And I'm thinking like he might just let you live. So rather than some callous refusal to save Jonathan Amerault's life, after having, I'm sorry, there's some real background noise there. After having refused to shoot Jonathan Amerault, she then is still thinking about saving Mr. Amerault's life when she's in the car for that moment that Armando is outside the car. So far from meeting the state, failing to meet the state's expectation that she would arm herself with a machete and attack Mr. Barron, Armando Barron, instead, she's still thinking about what can she do for Mr. Amerault. And bear in mind that what the state would have expected her to do at that point is, having been beaten, having had the gun in her mouth, having her head, a slash in her head, and both eyes black, and having been choked, they would have her attack Armando Barron, who is for a few moments outside the car. And bear in mind, he's armed with the very gun that moments later he shoots Mr. Amerault with. So their expectation, in order to demonstrate that she's not a danger to the public, would be that she attack an armed person where she does not have a firearm, attack him with the machete in that situation. And that's just not a reasonable or fair expectation to place on her in this context. So in terms of the events surrounding Mr. Amerault's murder, there's simply nothing about Britany Barron's behavior that demonstrates that she is a risk to the public, a risk to herself, or any sort of risk. And certainly the state does not carry its burden of proof by clear and convincing evidence using that evidence. As the court knows, Mr. Barron then compelled Britany to drive up to northern New Hampshire in an attempt to hide the body and hide evidence of the crime. And the state faults Britany in that context for not immediately notifying police when she had an opportunity, not warning the hunters who came up onto the scene, not taking some action when she was left alone at the campsite. And again, just as with the incident in Jaffrey, those arguments by the state are out of context. And I want to refer to the court to the relevant context for that. When, first of all, Armando Barron was present with her and she was following his orders when she removed the head from the body in this case, when they were trying to hide the body. It's not like he wasn't there and wasn't still a threat when that happened. Secondly, she told the police that she was waiting for Armando to shoot her the entire time they were at the campsite. She thought for sure that once she had served his function of helping dispose of the body, that he was going to kill her. While she was in the car with Armando, there's evidence that she contacted her coworkers and told them lies about where she was and what she was doing. In fact, it was Armando who forced her and ordered her to do those things to try to cover up everything. She was acting at his direction when she sent those messages to friends. And then I think most significantly, and this probably explains more than anything, the state makes a big deal of the fact that she was left alone, but what they don't highlight is that When Armando left her alone, he left her alone and he said, "I'm coming back Friday." And you would think, well, okay, well, then she's got plenty of time to go notify somebody. But in fact, the first time he left her alone and said, "I'm coming back Friday," he showed up by surprise in 1 hour, an hour later. And she had no idea that he was coming back. And what that means to someone in her situation, what it meant to her state of mind, is that Armando could come back and kill her at any moment. The same way that he had killed Jonathan Amerault, carrying out the same threat that she had made against her when he put the gun in her mouth, that she was constantly in fear when she was there. The state knows all of these things, 99% of these things, because when the police, I'll say law enforcement in general, Fish and Game, state police, and local police, when law enforcement in general were able to get her reasonably isolated and able to talk, she did nothing but that. She was initially reluctant, but within the first 40 pages of hundreds of pages of transcripts, she was telling them the complete truth and telling them information which was verified. She was expressing remorse. And her reluctance was that she did not want to betray her husband, that initial reluctance. And I'll talk about that more in a minute. But I'll just note that she didn't invoke her right to remain silent. She didn't ask for a lawyer. She didn't say, well, I want to wait and read what the police reports say in my case. Instead, she almost immediately gave a complete and truthful statement of all of her involvement, and her statements have matched up to the extent that we've got forensic evidence from the crime lab and other places yet. Her statements have matched up to the statements of other witnesses and to the forensic evidence. And I think it's significant to note, and this is in the discovery, Armando Barron is not a party to this proceeding, and his rights are not at stake. And so it's fair to look at how he responded when he was confronted by the police. He did not talk. He did not cooperate. He invoked his right to remain silent, and he invoked his right to counsel. And he has not made any offer to talk to the police, or he's made a suggestion at this point of a proffer, but he did not make any offer to talk to police before he had his discovery. That's a far cry from Ms. Barron, a witness who immediately tells the truth to the police at the beginning of the case and says everything that she has to say to the police. In that respect, I think the court should view all of her behavior in the context of a domestic violence victim. And I cited for the court the AG protocols for domestic violence cases. And to the extent that the state faults Ms. Barron for her conduct and for any of her statements, beyond the duress that she was under, beyond the threat to her life and everything else, her behavior pretty much exactly matches what the AG describes in every other context as the stereotypical behavior of a victim of domestic violence. I mean, I didn't make this characterization of a domestic violence victim up for this hearing. This is what the AG and frankly, social science has been telling us for decades, that frequently victims of domestic violence are afraid to talk. Frequently, they minimize. Sometimes they exhibit illogical loyalty to their abuser. They don't always come forward, and they don't always behave in ways that make sense. Now, those things can't be true in every other domestic violence case and not true in this case. And so I think what the court has to do, and again, it's in the context of considering whether she's a danger to the community or the danger to others in any context, is to look at the state's arguments that she poses a risk and remember their own description of domestic violence victims in every other case. With respect to one of my other arguments, that it's really pretty much a separate argument, but it's very important because it's one of the things that's changed since the start of this case. We argued bail 4.5, 5 months ago, and Ms. Barron has now been in jail for 5 months. She has not been charged with murder. She has not been charged with any other crime. And she's essentially being punished right now by having to sit in jail. And beyond the 5 months that she's been in jail, I think we all know as a practical matter, in fact, we discussed it at the last dispositional conference, we know as a practical matter that this case would not get to trial before the fall. It's just not realistic considering the additional investigation and discovery that the state has to do, the volume of discovery, the pandemic protocols, the other cases on the court's docket. I mean, October, somewhere between October and December would be the earliest this case could get to trial. So we're talking about punishing her with over a year of punishment when she hasn't been convicted of anything and when she obviously has a very strong duress defense. And I think that the court has to take that into account, not just under the bail statute, but as a matter of due process. And I won't reiterate the holdings of the cases there, but I provided the court with the case law on that, and I'd ask the court to recognize that case law. Lastly, I asked the court to recognize that we're not saying turn Ms. Barron loose with no supervision. We're not saying that the court should take no steps to ensure that she appears for court and that there's safety to the community. We're asking that she be released on home confinement at a location in Grafton County with electronic monitoring. We agree that the Grafton County House of Corrections, Community Corrections should be in charge of that. I have other clients that are on electronic monitoring with them. They're good and reliable. They're not going to approve a place for her to live that's not safe. We all know they're going to follow the court's orders. And I think that when the court considers the safeguards that electronic monitoring and home confinement would provide and that level of supervision, plus her good behavior at the jail, I checked with the jail and they report essentially that the time that she's been there, I mean, she has been no trouble whatsoever. Her behavior has been stellar is the word they use. And when you bear in mind that she does has family support, I think you see or did see that actually her brother was on for this hearing. His name is William Hernandez. He is a well-employed, good person that would come here to support her, will help her get set up and whatever she needs. I spoke to him as recently as yesterday. And I think with those safeguards for a release plan, electronic monitoring, home confinement, considering the family support that she has, and frankly, we would agree to any other reasonable conditions that the state would impose, the state would request and the court would impose. There simply is not evidence to support the idea under the bail statute that there's clear and convincing proof that she would be a danger to the community or that she would fail to appear to court for any court hearing. And so for those reasons, Your Honor, I'll answer any questions that you have, but for those reasons, we think that the court should release Ms. Barron on bail as we have proposed.
Okay, thank you, Attorney Guerrero. Attorney Chase, your reply?
Your Honor, just if you can let me know if you get any feedback. I'm having an issue with this monitor that I'm using. I
I
think.
can hear you fine so far.
Okay, good. Thank you very much. I think it's important at this point to address a few things that defense just raised and to clear up a few things. At no point has the state refused or ignored or failed to recognize that the defendant was in fact a victim of domestic violence that night. The state has appreciated since the outset of the investigation in the fact that she was assaulted, and that was recognized in the charging decisions. So was her duress defense. I know that Your Honor is aware of that as we discussed it at the arraignment hearing, but I think it's important to note that a lot of the arguments the defendant was just making and that he was highlighting, or the defense counsel, were considerations that the state made at charging. We considered that at the park, the defendant was arguably under duress, and she wasn't charged with any crimes. That's not where her danger stems from, Your Honor. Her danger stems from the decisions that she made after that, when she was given lawful alternative choices to make decisions that were not criminal yet she chose Armando's side. She chose his side, and every step that she took was in furtherance of ensuring that he evaded apprehension and prosecution, even though she was completely aware that he was an extreme threat to the general public. The defendant's danger to the public and her risk of flight hasn't lessened since the parties argued at her bail arraignment. In fact, those risks have only been heightened by additional facts, including those transcripts of her interview. I won't belabor all those facts, Your Honor, but I would like to highlight at least a few points, and then I'll answer any questions that Your Honor has. But at the arraignment, Your Honor, we noted that the defendant drove Jonathan's car with Jonathan's body in the back nearly the entirety of the state, hundreds of miles, with a cell phone, and not once made any attempts to call for help or report any crimes. Now, Your Honor, we know that not only did the defendant have a cell phone with her, she admittedly had a loaded handgun with her, the very gun she saw her husband shoot Jonathan with, a gun that she has shot before. Again, she had a car with gas, a cell phone, and a loaded gun, and she continued to side with the defendant. Even when the defendant would stop and get gas and she was parked down the street in a park, she made absolutely no efforts to take any lawful alternative steps. She was committed, she was following her husband, she was continuing to choose his side, and she was doing everything in her power to avoid any type of apprehension or reporting to law enforcement for her or Armando. And this is long after what happened at Annette Wayside Park. Furthermore, while she was packing, so after the assault, after Jonathan has been shot, they went back to their residence and they packed up to go north to dispose of Jonathan's body and the evidence. And while they were packing, Your Honor, she actually heard Jonathan moaning in the back of her car. And it's unclear when Jonathan stopped moaning. But what we do know is that even after seeing Jonathan get tortured and shot multiple times and hearing him moaning in the back of his car, she made absolutely no attempts to help him, to even while her husband was getting gas and she's parked down the road with a gun and a cell phone, to try to alert anyone or try to get any help for Jonathan or to make any lawful choice to avoid going to dispose of Jonathan's body and the evidence, Your Honor. Throughout their trip north and her time at the campsite, the defendant had multiple fortuitous opportunities to make reasonable alternative choices. But instead, over and over, she chose choices to ensure Armando's freedom, and she made unlawful choices in furtherance of Jonathan's murder. She chose to hide and destroy evidence. She chose to stay when she could have left, and her acts were all in the benefit of her homicidal husband, someone she knew was a distinct and incredible threat to the general public. And to that end, Your Honor, one fact that wasn't included in the state's objection is that when she was making those choices, when she knew that her efforts were to keep Armando free, she knew the danger he posed to the public, but also to one of her friends, a coworker. The defendant told investigators that she believed Armando had actually tried to lure one of her coworkers to the park that night as well, and fully expected that if he had been able to lure her to the park, he would have killed her just like he did Jonathan. The defendant did everything in her power to ensure her husband's freedom without any regard to the danger he posed to the public or that friend who she knew the defendant would have killed if he had Armando would have killed if he had the opportunity. And now, to the extent that we hear about this cooperation, the defendant did cooperate, but she only cooperated after she was caught. The defendant, even when her husband was hundreds of miles away, at no point took any step to help Jonathan, to flag down law enforcement, to alert authorities. Every time she was presented with an opportunity, she made an unlawful choice to further Jonathan's murder, to conceal and destroy evidence, and to ensure that a murderer walked free. The steps that Britany took, the extremes she was willing to go to avoid prosecution, is beyond shocking. And there is no question that she fully intended to do everything in her power to avoid apprehension and prosecution. She never intended on cooperating with law enforcement when she committed those crimes, which is why when she was first approached by uniformed conservation officers, away from and apart from her husband. She was armed with a cell phone and a loaded gun and standing there talking to two uniformed armed conservation officers. I believe the defense counsel used the term when she was reasonably isolated from law enforcement, she cooperated. There was no more isolation than when she was in the middle of the woods, armed with a gun, talking to two uniformed conservation officers, and she did everything she could to lie and to conceal what she was doing. She made no attempt to cooperate. She didn't cooperate until she was completely caught and was being interviewed by major crime detectives by New Hampshire State Police. In fact, you don't just have to look at the context of the situation. You can look to her very words, and I quote, she told the state troopers later on, "It's not like I went and told on him, you know, like I didn't go out of my way. I mean, like they found me." As Your Honor is well aware, in determining whether a defendant is entitled to bail, it's an analysis of the totality of the facts and circumstances. It's looking at everything. And again, the defendant's danger to the public is obvious and apparent, and it is directly tied to her husband's crimes in torturing and murdering Jonathan. While she may not have squeezed the trigger, she enabled the person who did it to remain free at large, continuing to be a danger to the public, including to a direct danger to a coworker and friend of hers. Her commitment to ensuring that he remained free was near limitless and involved shockingly gruesome acts of evidence destruction. And when you consider the totality of her acts, it is truly difficult to imagine what lengths this defendant would be willing to go to avoid prosecution. And as detailed in the state's objection, Your Honor, the defendant's willingness to side with the defendant over and over again, taking extreme steps to avoid apprehension, combined with her lack of connection to the community and her cross-country connections, make her a danger to the public and a considerable flight risk. And Your Honor, I'd like to briefly just address two final points, and that's the defendant's assertions, again, that she was a victim and that she was acting under duress. The defendant, again, was violently assaulted and threatened. The state is not ignoring that fact. We've taken that into consideration. But it's worth noting that neither of these points by the defendant are necessarily relevant to this matter or the charges that she is, the charges that she is facing, beyond the fact in the assessment of the likelihood of her conviction. To that end, neither of the arguments justify her being released on bail. By all accounts, on September 19th, the defendant was a victim of an inexcusable assault. However, that doesn't negate the criminal choices that she made and that she is charged with, and it does not diminish the threat she posed throughout those few days at the campsite to the public and continues to pose to the public. And as for her claims of duress, again, those were taken into consideration. We recognize that certain aspects of her conduct were done under duress. In appreciation of that, she is not charged with that conduct. But as detailed in our objection, it is doubtful the defendant would even satisfy her burden to get a jury duress instruction. The law is well established. There is no legal claim of duress if there is a reasonable legal alternative to violating the law, a chance to both refuse to the criminal act and also to avoid the threat and harm. If you have a legal alternative choice to violating the law and you do not take it, you are responsible for the criminal conduct thereafter that you partake in. And that's what she did. Every time she had a reasonable alternative choice, she made a criminal choice in furtherance of a murder. Based on, and Your Honor, actually, I do want to address one more point, and that's the case law that the defendant cited. Defense counsel cited. He discussed the punishment and pretrial detention assessment, and he cited the 10th Circuit, the United States v. Taylor, and he implies that Britany is being punished. She's not being punished. She's being detained because she is a threat to the public. And the 10th Circuit, in the case cited by defense counsel, it's United States v. Taylor, 602 Federal Appendix 713, and where I'm citing, Your Honor, is at pin 716. The 10th Circuit, specifically in quoting the United States Supreme Court, said, pretrial detention is permissible if it is regulatory and not punitive. Preventing danger to the community and assuring presence at trial are permissible regulatory reasons for detention. That is the entirety of why the defendant is being detained, is she is a danger to the public. And everything that she did and every bit of her charged conduct demonstrates the extreme danger that she poses to the public. And if Your Honor doesn't have any questions, I'm more than willing to answer any questions, but the state would obviously ask that you deny the defendant's request for bail.
Thank you, Attorney Chase. Attorney Guerrero, anything further from the defense?
Yes, Your Honor. I would ask the court to pay particular attention to the state's argument that they've given her credit for having been an assault victim. And I'd ask the court to note that the state's focus is on and limited to the violent assault of Britany by Armando at her home in the bathroom. And that is simply not the full context. I don't think the state can disagree with any of the descriptions I've given regarding the prior controlling behavior and prior violence. Nor do I think that they can deny that that she reported to them that she continued to feel threatened and that she thought Armando was going to return to the scene up in the North Country. And I would ask the court in particular to look at the domestic violence protocols, which I cited in my motion, which are from the Attorney General's office. And particularly pages 5 and 6, if you just click on the link in our motion, you'll see they describe domestic violence victims as sometimes engaging in behavior that doesn't make any sense, such as agreeing with the perpetrator's denial or minimization. And they give reasons for victim reluctance, fear of retaliation by the perpetrator, unwilling to face the perpetrator again in the courtroom, afraid of the perpetrator's anger, a feeling of shame or guilt, which I'll stop there on that one. I mean, that's to a normal sort of rational person outside of the context of domestic violence. You would say, well, why, we ask these, why would someone feel guilty about being a victim? And yet it's a recognized characteristic that for whatever reason, especially women and victims of domestic violence in these situations feel some aspect or shame of shame or guilt. And they also describe denial, ambivalence, or withdrawal and emotional mood swings as having been a victim of severe trauma. Remember, all of the conduct that they're describing Britany as having engaged in, it's conduct that she engaged in with a cut in her head, with a broken nose, with 2 black eyes, with a ruptured blood vessel in her eye, with a bruised neck from having been choked, and with bruises all over her body. I mean, it's not like she's, calm and possessed and sitting in a courtroom and had 3 hours to prepare. It's the exact opposite. They go on, the AG protocols go on to say that family relationships and ambivalence about her relationship towards the perpetrator may cause a victim to be reluctant or to have a reaction that doesn't make any sense. It notes that the victim and the perpetrator may have children together. It notes that there may be dependence on a family member. In this case, in fact, what is happening is that Britany's children are in the care of her mother-in-law. She is dependent on a family member. And lastly, it notes that they may have religious, family, or social pressures. This particular family was quite religious, and I think that probably contributed to the feelings of guilt and shame that Britany had that made her reluctant. So I would ask the court, as I started, to not look at her behavior out of context, but to look at it in that context and to recognize that she didn't wait until she was caught in order to cooperate. She waited until, or I wouldn't say waited, she didn't cooperate until the law enforcement actually convinced her that she was safe. That's when she cooperated. And if you want to describe that as waiting, fine. But when the police first showed up, of course, she didn't immediately realize that she was safe. And it took a while. And when she finally realized that she was safe, she gave truthful statements, which the state has corroborated. She's simply not a danger to the public or the community, Your Honor. We should release her. We'll resolve the case one way or another while she's on bail. We shouldn't punish her before she's had a trial. Thank you.
Thanks. Attorney Chase, last word, if any?
Yes, Your Honor, just briefly. Your Honor, the state fully appreciates the complexities of the fact that Britany Barron was a victim of domestic violence that night. There's no question about that. However, the fact that she was a victim of a inexcusable violent assault based on the facts that we have to date, does not excuse the criminal choices that she made later on. 2 points to that, Your Honor. One, defense pointed out that she made choices, that she refused to shoot Jonathan. She also refused to further dismember Jonathan at the campsite. However, she did make the choice, even after having the opportunity not to make any of these criminal choices. She made the choice to decapitate Jonathan, to bury his head separate from his body, and in her words, dump him in a brook in the woods, to leave him there. And to the extent the defense counsel implies that she was waiting until she felt safe and that's why she didn't talk with conservation officers, her own words when she was being walked out of the woods by Fish and Game was that I'm in big trouble. It wasn't that she felt endangered. The reason she wasn't talking to the conservation officers is because she knew she had been caught. And her admission of guilt or the fact that she's stating, I'm in big trouble, shows you her mindset at that point. It's not that she was fearful of Armando. She was fearful that she was in trouble for her criminal choices, Your Honor. And again, unless Your Honor has any questions, the state would rest further on its pleading.
Okay, thank you. All right, well, having considered the arguments in office of proof and all of the relevant factors that are appropriate for consideration under the bail statute when considering a request for preventative detention, or in this case, the state's request for continued preventative detention, weighed against the defendant's request for release on certain conditions, I find, well, let me summarize, but I find that for the reasons that the state has articulated in its objection and on the record, that the state has, again, established by clear and convincing evidence that the defendant's release would pose a danger to the public. Specifically, the nature and circumstances of the charged conduct clearly and convincingly demonstrate the defendant is dangerous to others. I agree with the state's characterization that her dangerousness is demonstrated by the series of decisions that she made over a considerable period of time and over considerable distances to destroy evidence and not make the legitimate alternative choices that the state identified. With respect to the defendant's, a few of the issues that the defendant raises, with respect to the fact that the crime with which the defendant is charged, not homicide as is her husband, but this, falsifying evidence and destruction of evidence, and that therefore she's not charged with a violent crime according to the defendant, although violence may not be an element of the offense as such, and violence is not a necessary element of falsifying physical evidence, at least in this case, the charged conduct, in the manner in which the defendant is alleged to have falsified evidence is exceedingly violent. To the extent that the defendant argues that she was a victim in this case of her husband's conduct, and the state concedes that to some extent and in some manner she was a victim. I would observe that the defendant's alleged victimhood and her dangers to others those two things are not mutually exclusive. That is, they can coexist, and at least in this case, I find they do coexist. At a minimum, the defendant's victimhood does not diminish her dangers to others, and in some respects may actually reinforce it. That is, the factors that the defense identifies as far as the domestic violence protocols and the dynamics that attend or inhere in the relationship between the domestic violence abuser and the abusee. Those factors may actually reinforce the defendant's dangerous. That is, for example, Attorney Guerrero had mentioned feelings of shame and guilt. Whatever feelings of shame and guilt the defendant may have had haven't suddenly evaporated. Those feelings and are still present and still able to actuate or motivate the defendant to act going forward, to the extent that fear of facing her abuser in court is a consideration as to why domestic violence victims may behave in certain ways, such as minimizing or not reporting. The defendant is still faced with the possibility and perhaps likelihood of facing her husband in court. So many of the domestic violence dynamics and victimhood dynamics that the defendant argues compelled her or to act as she did on the date of the charged conduct still exist, and if anything, they don't diminish her dangerousness, and they may well reinforce or amplify it. Again, as the state points out, the defendant had numerous off-ramps throughout the day, again, over a long period of time and over practically the entire length of the state, but chose not to take any of those, including the opportunity when confronted with two armed conservation officers to come clean or make some lawful alternative choice, and she did not do so. And again, I agree with the state that the conscious decisions the defendant made, albeit perhaps motivated by domestic violence dynamics, demonstrate her dangerousness and her dangerousness now. The defendant's, to the extent the defendant claims she was acting under duress, that may go to her guilt or innocence, as the defendant argues in its motion. But at least I find that whatever duress the defendant may have been under, apart from the fact that I think that's duress is substantially diluted by the circumstances in which she committed the charged conduct, apart from Mr. Barron and over a lengthy period of time, with the various opportunities she had to choose reasonable, lawful alternatives. But at least I find that whatever duress there may have been doesn't vitiate or dilute the degree of dangerousness that the defendant poses to others. Again, in part because of the nature and extent of the charged conduct, and perhaps as well the domestic violence dynamics that the defense identifies. Again, one of the things the defendant argues in paragraph 15 of the motion is that, summarizes there, is that the defendant did as her husband told her to do. And at least given the nature of the parties of the defendant's relationship with her husband and the evidence of the charged conduct on the date in question, there, in my mind, is still a substantial risk that the defendant will yet again do as her husband tells her to do. Again, the fact that the defendant may have or did refuse to murder Mr. Amerault or further dismember him, but merely cut off his head, at least in my view, doesn't diminish her dangerousness. And finally, with respect to the period of incarceration, I find that argument unavailing or unpersuasive for two reasons. One, if the defendant's dangerous, she's dangerous. And I find that the state has established by clear and convincing evidence that she is dangerous. Second, even if I were to apply the factors and balance of factors that the defendant enumerates in paragraph 22 of the motion. I find that the defendant's pretrial detention at this point does not amount to any sort of improper pretrial punishment. So for all of those reasons, I find that the state has continued to demonstrate that by clear and convincing evidence that the defendant poses a danger to others, that is the public, and therefore the defendant's motion to amend or modify bail is denied, and the state's request to keep the preventative detention in order is granted. Attorney Chase, anything further from the state?
No, Your Honor. Thank you.
Attorney Guerrero, anything further from the defendant?
Not at this time, Your Honor.
Okay, then. Thank you very much. This matter is concluded for now.
Brittany, I'll call you at the jail.
Thank you.
Thank you, Your Honor.